Chapter 13 bankruptcy affordability is probably one of the most important things that you need to consider. Hi, my name is Ben, and I'm one of the co-founders here at Ascend Finance. Ascend's goal is to take complex subjects such as Chapter 13 bankruptcy and make them into simple, understandable human language. Today we're going to cover Chapter 13 bankruptcy. The Chapter 13 bankruptcy is complex. How complex is Chapter 13 bankruptcy? Let's talk about statistics. 38.8% of Chapter 13 bankruptcies filed between 2010 and 2016 ended in discharge, which generally means debt forgiveness, and that is the goal of a Chapter 13 bankruptcy. Only 2.3% of those Chapter 13 files were successful when filed without an attorney. So these are when people file them by themselves. So it's very difficult to get a Chapter 13 bankruptcy discharge when you file without an attorney, and it's also complex with an attorney. It's just complex. So the purpose of this video is to break down Chapter 13 bankruptcy in simple steps with a focus on cost, because Chapter 13 affordability is a crucial aspect. Here's what we'll cover. Chapter 7 versus Chapter 13 bankruptcy overview. How much Chapter 13 bankruptcy is going to cost you? How long does Chapter 13 bankruptcy take? How your credit score and credit report are impacted? How to file Chapter 13 bankruptcy? The pros and cons of Chapter 13 bankruptcy? Chapter 13 bankruptcy alternatives? And should you file Chapter 13 bankruptcy? If you're like me, you're probably thinking, how am I going to get through all of this content? The last thing I would want to do is watch a video of myself speaking for over 10 minutes. So we added chapters below so that you can skip around to the sections that are most applicable to you. Before we begin, I also want to know that your debt situation is completely unique. My goal in this video is to answer all of your questions, but if I don't, please comment below and we'll try to get back to you as quickly as possible. Also, if this is helpful, I'd love it if you could subscribe. This is really encouraging to me, and it also motivates me to make additional unbiased content for you. Let's compare these Chapter 7 and Chapter 13 bankruptcy side by side. Chapter 7 bankruptcy is fast. You can receive a discharge in as little as 4 months. Chapter 7 bankruptcy is also less expensive than Chapter 13 bankruptcy. You may lose assets in a Chapter 7 bankruptcy, but many do not by using bankruptcy exemptions. The Chapter 7 bankruptcy is often a flat attorney fee, and that is paid before filing the Chapter 7 bankruptcy. There's some flexibility there, but many times you have to pay before you file. The total filing cost on a Chapter 7 bankruptcy is $338, and you often have to qualify for a Chapter 7 bankruptcy based on your income, household size, and state. A Chapter 13 bankruptcy is slow. The discharge often takes 36 or 60 months. A Chapter 13 bankruptcy is also often more expensive than Chapter 7 bankruptcy. You can keep your assets in a Chapter 13 bankruptcy. The Chapter 13 bankruptcy attorney fee is also generally a flat fee, and it's often paid some in the plan and potentially some outside of the plan. The total filing fee on the Chapter 13 bankruptcy is $313. There's no qualification needed for a Chapter 13 bankruptcy as long as you're within the Chapter 13 debt limits. And the Chapter 13 debt limits are $419,275 of unsecured debt by the making of this video. Next, we're going to cover how much Chapter 13 bankruptcy is going to cost you. In Chapter 13 bankruptcy, you will pay a monthly payment for 36 or 60 months. There are times where that can be shorter if you pay back 100% of your unsecured creditors, but many of those bankruptcies are 36 or 60 months. There are various things that go into the cost. And the Chapter 13 bankruptcy cost is based on your unique situation and location. The Chapter 13 bankruptcy affordability is probably one of the most important things that you need to consider. As such, we built a free Chapter 13 bankruptcy calculator, and I've included a link in the description below. The calculator asks questions unique to your situation and provides an estimate of the entire monthly payment of a Chapter 13 bankruptcy. It also includes all of the different costs related to Chapter 13 bankruptcy and compares to alternatives such as Chapter 7 bankruptcy, debt settlement, and debt management, which we'll talk about later. So let's break out the Chapter 13 payment in 3 different parts. 1, the Chapter 13 attorney fee. 2, the Chapter 13 trustee fee. And 3, how the fee is based on your financial situation. So first, the Chapter 13 bankruptcy attorney fee is often an upfront payment, and then the rest is sometimes included in the plan. There are instances where a Chapter 13 bankruptcy attorney will include all of the fee in the plan, but many of them take an upfront payment and include some in the plan. The Chapter 13 cost of the bankruptcy attorney is often between $2,500 and $6,000. So that number is often spread out, but it is a bigger number than a Chapter 7 bankruptcy. One of the least understood fees in a Chapter 13 bankruptcy is the Chapter 13 trustee administrative fee. The trustee basically administers the bankruptcy, so they are there throughout the process, and it's a percentage based on it's a percentage based fee, and it can also equate to thousands of dollars. This is also included in the plan. Just for your reference, the Chapter 13 calculator below in the description below also estimates the Chapter 13 trustee fee in your district. Third, your financial situation. Your financial situation determines the Chapter 13 plan payment every month. It takes into consideration various things, but we'll cover a few of them here. Disposable income. The amount of income you have each month after subtracting allowable payroll deductions and allowable living expenses from your gross monthly income. In a Chapter 13 bankruptcy, most of your disposable, if not all of your disposable income, will be used to pay back your unsecured creditors. Second, your assets. In some cases, the value of your assets could increase the amount of your Chapter 13 plan if your assets have large amounts above the non-exempt equity exemption. Wow, that's a lot of words. We'll talk, one of the more important things is to understand bankruptcy exemptions, and you are often able to protect your things using bankruptcy exemptions. Bankruptcy exemptions are a key component of Chapter 13 bankruptcy, so I would recommend that you visit the Chapter 13 bankruptcy exemptions article below and click on your applicable state to see the bankruptcy exemptions in your state. You can also see how to keep your home and how to keep your automobile and specifics for your state. Third, your debts. Some debts must be paid in full through the Chapter 13 plan. Priority unsecured debts such as taxes, alimony, child support, and administrative costs. Other creditors may receive partial payments, including your unsecured debts such as medical bills, credit card debt, and personal loans. Chapter 13 plans typically include back mortgage and car loan payments. Finally, fourth, recent financial transactions. Some recent financial transactions could impact your Chapter 13 plan. Another common question is whether you will be in a 36-month or 60-month Chapter 13 plan. 2 years is a big difference. So I'll also include a link below to help explain how the process works to determine whether you're in a Chapter 13 that's 36 months or 60 months. As I've said, we've already compiled this data in our Chapter 13 calculator, and you can take that via the link in the description below. Let's go through a real-life example to help you understand the cost of Chapter 13 bankruptcy before you even go to a consultation. I'm going to talk to you about a real-life example from someone I've been interacting recently, and we'll call her Brittany. Brittany came to us because her Chapter 13 bankruptcy was being dismissed. Dismissal is not the goal in bankruptcy. Dismissal basically means your creditors can come after you for that unpaid debt again. I asked Brittany some probing questions and found out the only reason she filed Chapter 13 bankruptcy was because the attorney fee, the bankruptcy attorney that she was working with, would only take $300 down and $120 a month for 3 years for Chapter 13 bankruptcy, or she would have to pay $1,300 upfront for Chapter 7 bankruptcy. Brittany couldn't afford the $1,300 payment upfront, so she decided to file a Chapter 13 bankruptcy. Let's quickly do the math for this. She could pay $300 down and 36 months of $120, which equates to $3,900 over 3 years, or $1,200 upfront. That's 3 times the amount for a Chapter 13 bankruptcy. I'm still not sure why the bankruptcy attorney didn't allow her to pay $300 upfront and then do payments for the rest of the Chapter 7, but that's a story for a different time. So instead, Brittany paid $300 down and then about 10 months of 120 months before her case was about to be dismissed. So Brittany paid $1,500 and didn't really receive any debt relief, when instead she could have paid $1,300 and received debt relief in a Chapter 7. What could have Brittany done instead? One thing, she could have gotten another bankruptcy attorney consultation and asked whether the attorney would take payments before filing Chapter 7. Many attorneys take payments for Chapter 7 bankruptcy as long as the fee is paid before the Chapter 7 bankruptcy is filed. So, as I said, the cost is very important in Chapter 13 bankruptcy, and understanding how much you will have to pay is crucial. Now, let's cover how your credit score and credit report are impacted in a Chapter 13 bankruptcy. Many people lump and credit scores into one bucket, and they are very similar, but I'm going to cover them a little bit differently. In regards to your credit report, a Chapter 13 bankruptcy is on your credit report for 7 years. You can often get access to credit much sooner than waiting those 7 years. And some people mention that they can get secured credit very soon after filing bankruptcy. In regards to your credit score may drop in a Chapter 13 bankruptcy. It really depends on what your starting point is. You may wonder how soon you can buy a house or a car after a Chapter 13 bankruptcy. And these are really important questions. So I've included a link in the description below how bankruptcy affects your credit and how soon you can be able to buy a house or car. Next, we're going to cover how to file Chapter 13 bankruptcy. The process to file Chapter 13 bankruptcy is similar across states. We will cover the decision of Chapter 13 bankruptcy, locating a Chapter 13 bankruptcy attorney, credit counseling debt education course, and completing your bankruptcy forms in the next section. The first step is really to determine whether you're going to file Chapter 13 bankruptcy, but for the sake of this video, we'll assume that you are, and so we'll go straight from there. Next, you're going to locate a Chapter 13 bankruptcy attorney. Even though you are not required to hire a bankruptcy attorney, filing Chapter 13 bankruptcy without a lawyer has a very low success rate. Chapter 13 bankruptcies, like we said, are very complex. Someone who does not understand Chapter 13 bankruptcy law could pay much more than is necessary to get out of that debt. Also, the court expects you to understand and know how the law applies to your case to represent yourself. The court will not explain the law to you, and it will hold you accountable for the errors you make in your case. It can be helpful to have a Chapter 13 lawyer handle your case. How do you find a Chapter 13 lawyer? There are a few different ways, and what are the benefits? There are a few different ways, but let's just talk about the benefits. A Chapter 13 bankruptcy attorney can be a trusted legal advocate who understands the bankruptcy laws, the local bankruptcy laws. They remind you deadlines and hearings, determines whether you should file Chapter 13 or Chapter 7. They calculate the lowest Chapter 13 plan payment possible. They can maximize the asset protection so you can keep your property, including your house and vehicle. They'll complete all the bankruptcy forms. They can guide you through the process through each step of the way. And they can protect you from aggressive creditors who want to take your money. The next step is to take credit counseling and debtor education courses. As part of the Chapter 13 bankruptcy is required to take 2 bankruptcy courses. The bankruptcy courses are available online from approved companies for a small fee. Moreover, the courses typically take about 90 minutes to 2 hours to complete, and you can find a list of the approved providers on the U.S. Trustee's website. The credit counseling course must be completed before you file a Chapter 13 bankruptcy. Also, you need to complete the debtor education course after filing your Chapter 13 bankruptcy petition. It is a good idea to complete the second bankruptcy course as soon as possible after filing Chapter 13 bankruptcy, so you can not forget and lose out on your chance of getting bankruptcy discharge. Next, you will be completing your bankruptcy forms. A typical Chapter 13 bankruptcy package can be 100 or more pages. When you file a Chapter 13, you must complete the bankruptcy approved form and any local form requirements for your district and court. Your bankruptcy lawyer completes the forms and reviews each form with you to ensure accuracy and completeness before the attorney files them with court. The forms for a Chapter 13 bankruptcy includes information about real estate, personal property, bankruptcy exemptions, debt, income, expenses, co-debtors, leases and executor contracts. The statement of financial affairs is also a form with almost 24 questions about your received financial transactions. It includes income for the past 2 years, recent payments to certain creditors and insiders, a list of lawsuits, gifts, contribution, leases, transfers, and other information. Your bankruptcy attorney will be able to assist you through those forms. Next, you'll file the Chapter 13 forms and attend court. Your bankruptcy lawyer will file your bankruptcy forms and obtain a case number. The bankruptcy court schedules a meeting of creditors and a confirmation hearing. In most cases, these are the only two hearings that the most bankruptcy debtors attend. Your bankruptcy lawyer will prepare the information for you to hear for those hearings and attend the hearings with you, in most cases. Once your Chapter 13 bankruptcy plan is confirmed, you will continue to pay that monthly payment for the duration of your term, whether that's 36 months or 60 months, or sooner if your plan is much shorter. If you have any problems or questions, you should contact your Chapter 13 bankruptcy attorney immediately. Your attorney is your direct guide, so you can complete your bankruptcy plan to get a fresh start. Next, let's cover the pros and cons of Chapter 13 bankruptcy. I'll go through the list one by one, and the list is not extensive, but it covers a lot of them. First, one of the pros of Chapter 13 bankruptcy is that you can save your home. Many people facing foreclosure can save their home and catch up on their payments through Chapter 13 bankruptcy. Next, there are some benefits of how to deal with the second mortgage in a Chapter 13 bankruptcy. There can be some favorable dealings with tax debts, potentially income tax debts in a Chapter 13 bankruptcy. You can often get help with your car payments in a Chapter 13 bankruptcy. You can get help with domestic support payments and arrears that can be caught up in the plan. A Chapter 13 bankruptcy can also stop evictions in certain situations. Let's cover the cons of Chapter 13 bankruptcy. First, there is a negative credit score and credit report impact, especially a credit report impact. Second, there are higher attorney fees in Chapter 13 bankruptcy than in a Chapter 7 bankruptcy. Third, there's often low payment flexibility in a Chapter 13 bankruptcy, meaning that it's very difficult to change your Chapter 13 plan through modifications and of sorts. I would say it's much more difficult than compared to a debt settlement case. Lastly, the length of time of a Chapter 13 bankruptcy is long. 36 or 60 months is a long period of time, and that definitely contributes to the difficulty of the case. There's a lot of information on Chapter 13 bankruptcy pros and cons, so I've also included a link in the description below of the Chapter 13 bankruptcy pros and cons that you can read through at your convenience. Thanks for sticking with me this far along in this video. If you have questions, please don't hesitate to ask below. I'll try to answer them as quickly as possible. Next, we are going to cover the Chapter 13 bankruptcy alternatives. There are 9 common bankruptcy alternatives, but we will cover the 2 most popular in this video. I added a link to one of the articles that covers the different options as well. Also, you can compare the cost and duration of these bankruptcy alternatives using our Chapter 13 calculator below in the description. First, debt settlement. Debt settlement is one of the most common alternatives to Chapter 13 bankruptcy. Debt settlement is where a debt negotiation firm or you would negotiate delinquent debt for less than it is owed. For example, a debt negotiation firm may negotiate a $10,000 debt to a $5,000 debt and then charge a fee. In certain situations, debt settlement can be less expensive and get you out of debt faster than Chapter 13 bankruptcy. That said, there are pros and cons of debt settlement that you need to consider. For example, in debt settlement, you may be liable for forgiven debt that is based on the negotiation amount. Second, there is a chance of lawsuit in a debt settlement case. Now, there are certain creditors that are more likely to sue than others, and so it's important if you do debt settlement to understand which of those are more likely to sue. And third, there are some firms that it also does impact your credit score and credit report, and there are firms that are less likely to potentially work with a debt settlement firm. Often, credit unions. Most firms or many firms will work with debt settlement companies, but you need to know the differences. Another common alternative is debt management, also known as credit counseling. In a debt management program, a credit counseling agency would negotiate the interest rate with your creditors. For example, a credit counseling agency may negotiate your credit card interest rate from 23% to 9%, and then you pay a lesser amount over a fixed term. Debt management is often best with high interest credit cards because personal loans are often not included in the debt management plan. You also may save less in a debt management program than a debt settlement program because the interest rate reduction may not save you as much as a debt amount reduction. Finally, the question many people want to ask is, should you file for Chapter 13 bankruptcy? Deciding whether to file Chapter 13 bankruptcy is ultimately your decision, and your situation is completely unique. In summary, you are the best person to determine whether to file a Chapter 13 bankruptcy or not. Our Chapter 13 bankruptcy calculator can help you understand the costs and the duration and your alternatives and compare pros and cons in the description below, but ultimately it's your decision and you should be the one that makes that decision. Did you learn something in this video? Please just click subscribe below and we'll hopefully make a lot more content that will be helpful in breaking down different terms to make them very simple for you to understand. Finally, I'll turn it over to you. What are some questions that you have about filing Chapter 13 bankruptcy? Please comment below and I'll do my best to respond as quickly as possible. Thanks so much for watching.